There's one change to the agenda today, and that is Torrance Refining Company LLC case 6060-4, emergency, and AOC is off calendar. We will be hearing today the South Coast Air Quality Management District versus SMC Grease Specialist, case number 6062-1. Just as a means of order, the chair is not here today. Chairman Camarena, the Vice Chair Prusak is not here today, and I will be serving as chair as their designee. Okay, who's representing the district today?
Good morning, board members. Nicholas Sanchez and Daphne Sue on behalf of the executive officer.
And who's representing SMC?
Sal Coco and Tula Coco.
I'm sorry.
Sal Coco and Tula Coco.
Okay, thank you.
I'm sorry, just a moment. When you speak, press the microphone. Okay, yeah, okay, just press the microphone, and then when you're not speaking, make sure the microphone is off because it will pick up everything you're saying.
Okay. All of those who will be testifying today, would you please stand to be sworn in? Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can have a seat. Okay, just as a word to the respondent, Coco, Mr. Coco, Ms. Coco, I see that you haven't been before us. This is case number 1. So just as a word to you, what we're going to do is we'll have opening statements, brief statement by the district. You'll have a chance to make a brief statement. Then we'll go back to the district, and they will call witnesses, and you get a chance to also ask questions of those witnesses. The board will also ask questions of those witnesses, and then you will also have an opportunity to explain your case in more detail after that. Okay. So, Mr. Sanchez.
Thank you, Chairman Byrd. The matter before the board today deals with the company that obtains and renders restaurant grease. They go to locations, obtain their material, and bring it back to their plant and treat it to separate it into commodities. As part of the operation of their business, which is located in Colton, California, they own various portable engines on trucks, which they use to power to obtain the material and pump it back in at their plant. Beginning in June 2014, district inspectors came across the engines operating at their facility, and at the time noticed that 2 of them did not have district permits to operate. Pursuant to district rules and district rule 203, engines operating at 50 brake horsepower above require a district permit. Upon discovering that, the district began communications with the facility and had additional inspections. Again, in December 2014, they inspected the facility and the equipment at the facility and discovered additional engines that were operating without district permits. Following that discovery, the district began communicating with the facility. They have been cooperative and they tried to obtain permits for some of those engines. Based upon the age and the horsepower of those engines, many, if not all of them, are unable to obtain permits. The facility has proposed a compliance plan, but the issue before the board and the challenge with the district is based upon the operations, it is not clear what sort of permitting may be necessary, because they do operate at various locations, which would provide for a various locations permit for the engines on the trucks. However, they return to the same facility and pump the material ongoing, which would require a stationary permit because the emissions are constantly generated at a single source, and it's known to the facility, and those emissions need to be evaluated. And we're still doing our analysis on what is needed for this facility, and based upon the emissions and ongoing emissions, that's why we have not stipulated with the facility on what plan is needed. They have proposed to electrify the operations at the facility, which is something that would clarify some of the issues, but the time frame and whether that will satisfy the needs of their operations is not clear. It may appear that they still may need to operate the engines, which wouldn't solve the problem of pumping at the location. Based upon that, we've issued 2 NOVs for the observations in June and again in December 2014. What I've provided to the board and asked that we mark those documents now is the compliance plan provided by the facility, a diagram of the operation of this equipment, and a notice to comply that was issued by the district to the facility. If we can mark those documents at this time.
We'll take a moment to have the clerk provide us with those documents. We have received 3 documents. One is a notice to comply dated 8/4/16. And did you have any particular order that you would?
I don't have any preference.
Okay. That's Exhibit 1. Then we have a document with a heading of SMC Grease Specialist, Inc., Engine Replacement Plan. We'll mark that as 2. 2? Yes. Then we have a flow chart with a heading of Pumping Truck Auxiliary Engine Flow Chart Usage. We'll mark that as 3. Okay, Mr. Sanchez.
Thank you. The message to the board today is the use of these engines and the manner that they're being used and their impact on this industry is unique. The district had pursued proposed rulemaking for rendering facilities and grease rendering facilities. That has been paused. However, the requirements on portable engines are not unique, and so for that reason, that's why, based upon, the district may be willing to modify its position based upon what's presented by a respondent today. But at this time, based upon our need for further evaluation and depending upon the length and time and usage of these engines before they're removed from service, puts us in a position to seek that they stop operating until we receive clarity on what their path for compliance is going forward. Thank you.
I'm not sure who will be speaking, but one of you can make your opening.
Thank you. Sal and I are the owners of SMC Grease Specialists. We are a recycling company. We don't just recycle oil. We recycle waste products, interceptors, what have you. We are a green company. What we do and what we designed to do is to recycle items that stay away from landfills, items that take 100 years to disintegrate. We recycle. So with that being said, us being a green company, we would be contradicting ourselves if we weren't in compliance with SCAQMD because that makes no sense. We were never aware that we needed to have our motors that are on our trailers permitted. Had we have known that, we would have done it from the beginning. I could even show you later on, if you'd like evidence, a binder of every license permit you could imagine that we have and have had since day one of business. So this is definitely something that we were unaware of, so nothing that was done intentionally. We did receive our first violation when an investigator came out because of an odor complaint. What we do doesn't smell pretty. We are in a rural area, but some people don't care for it when they are next to us. At the time that we got that violation, the gentleman mentioned that we have 2 of them. We were not told that we had a timeline to comply or what have you. Thus, 3 months later, they came back out and issued us another violation. However, what we did not know, and I think all of us did not know because this is new to everyone, is that these pumps take 90 days and in some cases longer to order. So the engines, sorry, I call them pumps, but the engines. So we couldn't even if we wanted to comply within that 90-day. And again, we didn't even know that we had a deadline. We were not told, you have 30 days, 90 days, 60 days, what have you, to comply, or you're going to be issued an additional violation. So the second violation, I feel, was not granted, in my opinion. We have taken all the measures possible to do our research to find out what we can do to comply. There's been a lot of ambiguity in this department. They have been extremely helpful, yes, but I think both sides are still a little confused as to what needs to be done because it is a little bit of a unique industry as far as the pumps go and how we utilize them. We utilize our pumps on average 15 minutes to an hour a day. That's the maximum time that they get used. They're turned on to suction a pit or what have you, and then they're turned off. We do use them in multiple locations, so we definitely go out to our customers wherever they may be in Southern California. A driver could have one stop, a driver could have 4 stops, so that'll determine how many times it's been used, and it takes approximately 10, 15 minutes per location. And then it comes back to our yard and we unload it, and that's again another 10, 15 minutes to unload. We want to be in compliance. We are not set out to do anything under the radar or anything like that. We are a company that invites OSHA to our property to make sure that we're in compliance and doing everything correctly. I don't like to have surprises at the end of the day. I'd rather do it correctly the first time around. And again, I don't know how we could have done our due diligence to have known that a pump, an engine motor that operates a pump needed to be permitted.
I'm sorry.
That's correct. When the state of California passed the emissions law, we are complete compliance with that. When we had older trucks and we were told that we either had to modify them up to the standards or that we had to have them replaced with newer vehicles. They gave us a timeline to comply 50% of our fleet by a certain deadline, 75% of our fleet, and then 100% of our fleet. And we are in complete compliance. Once they told us that, we followed whatever they've asked, and we complied with all of their wishes and have our certificate of completion.
Thank you.
Thank you.
Could you, I'm sorry, for the record, could you state your full name and your title with the company?
Dimitra Tula Coco, and I'm the CFO.
And can you spell your first name, please?
Dimitra.
Thank you. Mr. Sanchez, your first witness.
Yes, I would just ask, because the opening covered a lot of information, that it be admitted as evidence.
Do you have any problem admitting your opening? Okay, we'll admit that as evidence.
Thank you. The district would like to call Amanda Sanders. Ms. Sanders, can you please state and spell your name for the record?
Amanda Sanders, AMANDASANDERS.
And did you take the oath?
Yes, I did.
And who is your current employer?
SCAQMD.
And what position do you hold with the district?
I'm an Air Quality Inspector 2
And how long have you been employed by the district?
since 2010.
And as part of your assignments, does it include the facility that's appearing today, SMC Grease Incorporated?
Yes, it does.
And have you inspected the facility?
Yes, I have.
Beginning on what date?
I inspected the facility on 8/4/16.
And have you had subsequent inspections and interactions with the company and their owners?
Yes, I have.
And can you describe what's the nature of your understanding of the nature of their business?
That they pump grease or wastewater materials from customer locations, then bring that material back on site and pump that into holding tanks on site to be processed.
And what equipment, if any, do they operate or subject to district rules and regulations?
They have portable engines that can operate at the customer locations or on site. And they also have a boiler that's subject to registration at their facility property.
And what do the district rules require in regard to the use of portable engines?
District rules require that any engine rated greater than 50 brake horsepower have a district permit.
And did you observe how many engines and their rating at the facility?
And during my initial inspection, I found 2 engines at the facility that were rated greater than 50 brake horsepower as indicated by their data plates.
And did you do any further analysis or inspections at the facility to determine how many engines they use as part of their operations?
In subsequent email correspondence with the facility, I obtained a list of engines for their fleet that indicated they had 6 units that were subject to permit. And during a follow-up arranged inspection, I was able to inspect all the units.
Listed in the proposed findings, there's 5 engines. Why did that amount change from 6 to 5?
There is 1 engine that has a current pending application with the district to obtain a permit, and so that one would be in compliance until we deem it acceptable or not.
And did you ask, who did you speak with when you asked about the engines and whether they're being operated?
During my initial compliance inspection, I met with Ms. Tula Coco, and she had referred me to her husband, Sal Coco, for further clarification about the use of the engines. She wasn't too sure at that time. And then so during my follow-up arranged inspection with another district staff member, we met with Sal Coco, and he was able to further clarify that the fleet of engines are used in the field and at the facility to pump the material.
And the engines that are listed in the proposed findings, can you walk us through and describe them for us?
Yes, 1 engine is a Deutz. Do you want me to be specific about model serial number?
Yes, please.
Okay, so model number F4L912, serial number 8187360, was rated at 68 brake horsepower. There was a second Deutz engine, model number BF4L2011, serial number 10332971. That one had an unidentifiable brake horsepower.
Let me pause you right there. And what do you mean by that you weren't able to identify the brake horsepower?
There was no data tag on the unit to indicate what the horsepower rating was, nor was there any paperwork provided to prove the rating of the unit.
And were you able to determine, any other identification of the unit to give you an idea of maybe what the emissions were from it?
I did observe that it was a 4-cylinder engine, and based off my experience in inspecting engines in the field, a 4-cylinder engine would be rated greater than 50 brake horsepower and subject to SCAQMD permit.
And how does a district approach equipment that has insufficient identification to determine whether it's in compliance?
That the facility holds the burden of proof to demonstrate that the unit is in compliance and whether or not it requires a district permit.
Do you try to work with the facility or manufacturers to try to get as much information as you can to determine its compliance?
Yes, I did, and the other staff member that conducted the follow-up inspection with me also tried to reach out to the manufacturers to get more specific information based off the information we obtained, and we were not able to clarify what the brake horsepower was of that unit.
Okay. Can you continue describing the remaining engines, please?
Yes, and there was also 2 John Deere John Deere engines in the fleet. The first one, they both had the same model number, 4045DF270B, and serial numbers are PE4045D415862 and PE4045D415864. And based off the data tag, those units were rated 80.46 brake horsepower.
And the last engine?
The last engine did not have a data plate on it. The unit was comprised of 3 cylinders. The tank that the engine was mounted to operate with was labeled as T4.
And who created that numbering system? Was that from your records or used by the facility?
That was used by the facility to number all of the tanker trucks.
And were you able to identify the vehicle that engine is mounted on?
Yes, I was. The actual trailer has its own California license plate.
And I'd like to show you what's marked as Exhibit 2. Do you recognize that document?
Yes, I do.
Who did you receive it from?
I received this from Sal Coco.
And on that, and what's your understanding of what this document indicates?
It was his plan to replace the engines in his fleet. It was his compliance plan indicating the engine that would be installed to replace certain engines mounted to certain trailers, and it even indicates a replacement date for each unit.
And so on the top of that page, what's listed as T4, is that consistent with the engine you described?
This is the new engine that would be replacing the T4 unit that we previously found.
Okay. Is your understanding that T4 as described in the petition is still being used and in service by the facility?
Yes.
And as part of your interaction with the facility, I'd like to show you what's been marked as Exhibit 1, the notice to comply. Do you recognize that document?
Yes, I do.
And can you describe it for us, please?
Yes, it's a notice to comply issued to companies to either request information or correct minor violations.
And did you prepare this document?
Yes, I did.
And you served it to Mr. Coco as indicated on the document?
Yes, I did.
What were you asking from the facility with this notice?
I asked the facility to provide me details of their compliance plan, specifically the timeline in which they would be replacing engines. I needed to know specifications about the engines they would be replacing their current engines with, and then also any details as to how they would plan to stop using engines at their facility to pump into their holding tanks.
And so Exhibit 2 was submitted in compliance with the notice?
Yes.
And were all the requested information provided by the facility?
Yes.
Okay. And you mentioned that I had mentioned in my opening that the facility had planned to electrify pumping operations at the site. Were you aware of that proposal?
Yes.
Can you elaborate on it, please?
The facility provided photographs of an electric pump that was already purchased and is being installed at the facility. They were indicating that it would significantly decrease any engine emissions because it would stop them from having to use engines at the site to pump material out into their holding tanks. There was just a small, maybe rare occasion where an engine would have to be used because of a higher viscosity of material, requiring that the pump could not meet that power requirement.
I'd like you to look at what's been marked as Exhibit 3. Do you recognize that document?
Yes, I do.
Did you prepare it?
Yes, I did.
I mentioned in my opening there's an issue of whether a various locations permit or a stationary pit permit would be needed. Can you walk us through the document and explain why, unless the facility electrifies, there seems to be some it's not clear on what the compliance path may be?
Okay, so at the very top of the diagram, there's a box that says job site pickup location. So this could be any of the various customers that any of these pumping facilities could service. They're picking up grease or wastewater. So from that, if you drop down the middle, you can have a contractor that comes out to these sites to pick up and pump material from those units. And then that contractor can end up going to a company like SMC Grease, where they're dropping off the material to be processed or rendered. Also in that flow chart, if you follow going straight down and then go left, and you go down to the company where it's labeled drop-off location. So sometimes these companies will have their own trucks, fleet of trucks that can go out to the customers like SMC Grease does, and they'll go out and pick up the material and bring it back to their own company. And so that's another scenario where these pump engines are being used. That company, then if you go down to the right side of the flow chart, you can also have in the field these contractors go out to any of these various customer locations to pick up material and then go to any, any facility to drop off this product. So it's not really going to maybe the same rendering location each time.
So let me interrupt you there. So is my understanding that SMC operations is they have their own trucks, they pick up material, and they bring it back to the same place, which is their plant, to treat the material at their facility.
Correct.
And so how does the district distinguish a various permit versus a stationary source permit? And if you can explain on the uniqueness of this situation and this facility's operations.
So my knowledge of permitting requirements is that we consider a stationary source to be one where there is a reoccurring need for a piece of equipment where it may exceed a 12 consecutive months of operation. Like in this case with SMC Grease, they have a need to pump material at their site. So the continued use of those engines at their site demonstrates that those emissions from those engines are contributing to their stationary source emission profile. And typically the district would like to evaluate those emissions and conduct a certain health risk analysis to permit those units or not. Various locations units are ones that operate typically in the field or moving around, are truly a portable type of source. Most often don't go back to the same types of locations or only go for very specific short projects.
So the goal is if they're going to come back to the same place and run the engines frequently at that location, the district wants to be able to evaluate those emissions,
Correct.
as opposed to a facility that just goes out, uses their engines at various locations, and it only occurs off-site.
Correct.
Okay. And would electrification at the plant possibly resolve the need to not have a stationary permit for these engines?
Yes.
Okay. And based upon the timeline you saw in Exhibit 2, is it clear on when the electrification is to occur at the plant?
Yes. He indicates that in a statement that the electric pump will be up and running by 10/31/16, and it's going to be used to pump most material from the trucks.
Does the district also have a concern on whether the trucks will be used to operate the engines as opposed to the engines operating independently?
Yes.
Can you elaborate, please?
So another type of application for these pump trucks is that there is a system identified or known as a PTO system. It's a power takeoff system. And with those type of trucks, those systems are operated off of the engine on the truck itself. So they don't require a second engine to drive the pump. And so they would have to idle that truck at any of these locations to operate the pump. And that is something that the district has concerns over evaluating the emissions from that.
Okay. And as part of your review of this facility's enforcement history, do they have outstanding NOVs for using these engines without permits?
Yes,
And how many NOVs were they issued?
there were 2 NOVs issued in 2014.
Thank you. No further questions.
Ms. Coco or Mr. Coco, do you have any questions of the witness? I do. Okay.
At the time that we were issued our NOVs, were we given a timeline to comply?
I was not the district inspector who issued the notices of violation. I would have to refer back to the violation reports, and I would have to ask for a minute to see if it indicates that.
Because I do understand the first violation, but when there's no timeline to comply, I don't understand the second violation. And also these violations, I know that you and I have spoken, and actually there's been 7 different parties to this that have been involved. This is all new to all of us, is that correct? We're still kind of learning about this. There's a lot of ambiguity in terms of this pump. We have been cited, we have been charged fees, and then they realized they were in error and they gave us back our fees. So there's still a lot of ambiguity in this area. Don't you feel that's correct?
I can't speak confidently about what discussions went on with like previous inspectors and in follow-up to that. My knowledge started within this last few months when I started doing the inspections at the site. However, in looking at the compliance history, I did observe that the facility had submitted applications after the issuance of the last 2 notices of violation. And the applications that were submitted were for engines that could not meet backed emission requirements. And I'm not sure as to the correspondence about those requirements, if it was provided to the facility or not.
Okay. Thank you. No questions.
Board members, any questions? Okay, I have a couple. At this facility, you said there were engines, portable engines, but there's also a boiler. Is the boiler under permit with the district?
It's subject to registration and it is registered.
Okay. And then you mentioned that one of the engines had a current pending application. Do you know what the date was for that?
Let me just take a quick look at my notes. Oh, I have it right here. The date. So it looks like, I'm sorry, let me look at this. Is it this date on the plan? That's the receipt date? I apologize, I just need to ask a quick question.
I can call a witness regarding specific permitting
Okay.
questions if you would like.
Okay, I had a couple questions regarding permit, and I didn't.
I could answer that question.
Oh, hold on a second.
And just looking at the application folder, it looks like the received date that's indicated for the application was 3/3/15.
Okay. And I'm not sure if you're the person who would answer this question, but you did mention that applications had been submitted, but the engines could not meet backed. The procedure for the district in receiving applications, and you may not be the person to answer this, I think we probably have an engineer here, permitting engineer, but since you're here, is to receive an application for the permittee to submit their fee and to be given an opportunity to operate because of the submission of the application as a temporary permit to operate. Is that typically the way it works? Do you know?
Yeah, typically when I follow up with the facility who's not in compliance, if an application is required to obtain a permit, I will go through the route of making sure that that unit can get a permit and then instructing the facility as to how they submit the application. And then once they submit it, it can act as a temporary permit while we're still evaluating the application.
And then once the permit application is evaluated, if they cannot meet the requirements, then they are given notice that these engines will not be able to be permitted. Is that the typical route the district takes?
So long as it's pending and it's accepted for review, then that is acting as the temporary permit to operate. Once it's rejected or canceled, then they no longer have that temporary permit status, and then they could be subject to further enforcement action if they're still operating the unit.
And do you know then, is it a letter that is provided to the facility if they don't meet the requirements for the permit?
I believe so, but I'm
rejection.
not as knowledgeable in that.
Okay. Any other questions? Mr. Lofgren?
I'm a little confused in terms of the proposed findings. There have been a number of different pieces of equipment identified, 2 Deutz units, 2 John Deere, and 1 unidentifiable. And then on Exhibit 2, the engine replacement plan, they all refer to Deutsch, and I'm sure I'm just missing something basic here. But could somebody explain what the 5 Deutsch relate to, and are these some or part of what's in the proposed findings, or are they something new? They all say they're diesel, so they apparently are not the electrifiable system which is going to go into place. I'm not sure who to address the question to, but that's a question I have.
Okay, so In the proposed findings, we list the engines that are not in compliance that require district permit. So there's 5 units identified there. In the exhibit, identified stating SMC Grease Specialist Engine Replacement Plan. That is the facility's plan to replace each of those units that are in their proposed findings list. So they identify which units are going to be replaced in a specific order in that plan. So they're saying that the first unit that they would replace would be the one that is unidentifiable as indicated in the proposed findings. So that they give a clear timeline as to how quickly they can replace these engines with this one particular Deutz engine that they propose, and which is rated 46 brake horsepower and would not require a district permit. And then also as a statement in that plan, they're indicating that they would start reducing emissions from diesel engine usage at the facility by running the electric pump.
Okay, thank you.
Senator Holton?
Yes, Madam Chair. Ms. Coco, how long have you been in business?
Hold on. Do we have any more questions for this witness before we switch? And we're going to take the district
Oh,
witnesses
thank you.
first.
No, not for you, ma'am.
Okay. I did have one other question. With Exhibit 3, it appears that you have presented information that shows that it would be possible for, in the interim, the facility to use another contractor? Is that what this is? To at least pick up the grease waste and then bring it back to their site? Is that what you're proposing in Exhibit 3?
It could be possible because there are other companies out there that pump material from, companies, like they conduct a similar operation. However, I couldn't confidently inform you that maybe those companies have required permits, or if they would operate with an auxiliary secondary engine, or if they operate PTO systems. Those sources are both out there in the field.
Okay. I wasn't, then maybe you can just explain to me what you intended by presenting this exhibit. I wasn't sure.
The exhibit was prepared to demonstrate that the permitting requirements within this industry for these kind of pump engines can be a little bit more complex than just a facility like theirs, where it may be a little bit more straightforward, where they own their own engine, their own truck engines. They're going out in the field. Those units are being operated there and returning to their home location. We were showing that to be fair and even-handed with permitting similar operations for other companies that operate in the field or conduct the same service, that there are other scenarios that those units operate under. And we're still evaluating that process.
Okay, thank you. As far as the respondent mentioning that this is a learning process and there's been some discussion with the district about learning, what is your interpretation of that?
Well, as we went over what a stationary source is and what a portable source is, typically the district for this type of facility, we would require that they have a permit to operate their units out in the field, and then to also have, for that same engine, a second permit to operate that engine at their stationary location. So there would be 2 permit application costs for that unit. And if that unit doesn't comply with the permitting requirements, they would have to not only replace that engine and incur that cost, but have to pay 2 application processing fees for that. And right now we were trying to explore if certain companies needed to have 2 permits, or if 1 permit would be sufficient to operate in the field. And in their case, if they're not operating at their location anymore because of an electrified pump, then only 1 permit would be required. But it can be kind of complex depending on the scenario.
Okay, but does the district have other facilities that have similar issues with requiring 1 or 2 permits for the same equipment?
Yes.
Okay, so this is not new. I guess I'm trying to understand the learning part that's been proposed, that this is a learning.
I think that more of these situations are being discovered out in the field during inspections, so I think that's why it seems new.
Okay. And as far as, you were there in 2016 and issued the notice to comply. Do you know how many other times inspections were made in the last couple years?
I recall when I looked at the compliance history, the initial inspection was due to a complaint response regarding odors. That inspector did conduct a few inspections at the facility, 2 to 3 inspections at least, and follow up to those violation notices. I know that district staff had reached out to this facility. I also accompanied them during a planning rulemaking process where we were gathering information about the potential odor sources, and we were just trying to take a look at.
Can I just interrupt you
ahead.
for just a minute, and can you give me approximate dates of when these, or at least the year, when you mentioned the initial complaint that
Okay.
caused the district to go out?
Yes, let me just refer to that notice. So the complaint was received on 6/19/14.
Okay. And going out for rulemaking process was approximately?
It was in 2014, early 2015. I'm sorry, I don't recall that date.
When you went out to the facility during those times, was there a discussion about the engines and the fact that they had received notices of violation as to when they might come into compliance or anything like that?
The other district inspector is the one who followed up on the violation notices that they issued to the company, and that was in 2014, early 2015. When I visited the company with the rules and planning staff, it was directly just to gather more information about the industry and see what their best management practices were regarding, housekeeping practices and trying to mitigate potential odors issuing from the facility.
And is there anything in the record that would indicate whether or not the inspector who issued NOVs spoke to the facility about timelines when compliance would be expected?
Yes, in the reports, I will go refer to the second violation notice that was issued. They have record of, visiting the facility and speaking with either Mr. and Mrs. Coco regarding submitting applications to come into compliance, and attempting to make contact to inform them to also contact the on-call duty deputy for the district to seek any relief that they may need to continue operating the engines that were subject to permit.
And that would be the notice that is dated 12/12/14.
Yes.
Any other questions?
Ms. Sanders, in terms of the location where they retrieve this grease or whatever, and then where they finally deposit it at this for processing at their location, how many such locations, to your knowledge, where they retrieve that that contaminant?
From what was discussed with me, I was informed that it varies. So their customers could require material pickup on a constant basis, or it can be every few months. It could be once a year. It just depends on that company's needs.
So it may be at one location, 2 locations, 3 locations. It could be 10 locations, depending on the needs.
It could be, yeah, I think what's limiting is probably the storage capacity of those tanks and how much material they have to pull from each stop, and then how often they send that truck out.
So based on the current requirements, permitting requirements, then I think you're saying you need a permit at this place where it's retrieved and where it's finally processed.
Yeah, they would need a various locations permit to operate in the field at the customer pickup locations. And then if they're operating it at their stationary location, then a permit there.
But you also said that it's yet to be determined whether or not they would get by with one permit or maybe need two permits, where it's retrieved and where it's finally deposited and processed.
There are some other scenarios where we were looking at where maybe it's just a contractor picking up material, going to the same, like to a certain stationary location to drop off material. And those contractors were looking into further what those permitting requirements are, if they're just solely a various location source. But like for this type of facility where they own and operate their own trucks, if they're going out in the field and we know that they're always coming back to their station, their location, then we're requiring a permit in the field and a permit at their location.
So there's no real protocol. Is there a standard that they're to comply with? I think the testimony was that they don't know what they're supposed to do at all times.
I know there's permitting standards for engines, and I'm not one to speak well on that. I don't have enough knowledge on that.
I'm based talking about the various locations now. If they're working all around the general area, say a radius within 50 miles, there may be a need for them to retrieve this grease contaminant and then take it to the location for processing. They may not know at any time where that might be.
I think overall, it's just understood that a district permit is required because those engines are not exempt from permit.
All right, now, he's hearing here, the engine replacement plan is Exhibit 2, where they would be, the horsepower would be 46.6. Would that require a permit?
No, it would not.
In each case where the diesel engines are being replaced, it would not require a permit.
This is a proposed plan, and part of the proposal was that they were going to test out the first engine that they were purchasing to see if it can meet the needs of the pump, because like stated before, if there's certain deliveries where the material may be very viscous, they need a stronger engine to power that pump, and they were not completely confident as to whether or not that would work for this application.
To your knowledge, have they started the testing program?
They already purchased the unit from my last conversation with them, so they were still needing to obtain it.
So to your knowledge, they purchased 6 units,
They purchased one, at least
One.
to my knowledge, yeah,
and the others would follow if it functions
correct.
according to the plan. Well, so to you, seems like they're making an effort to comply?
Yes.
Thank you.
Just have one follow-up question. The notices of violation say the operating without a permit. So they were operating without a permit for various location use as well as for stationary use. They had no permit at all.
Correct. The district inspector notated that they observed the engine operating on location a couple of times, and then they were also provided records where the unit was operating in the
Off
field.
location. Okay, thank you.
Mr. Chair,
And that was since 2014.
Yes.
Thank you.
one final question.
Senator Holden.
Here is, in the findings, it says, clearly states that the district inspector searched for a California Air Resources Board registration database. Why did you do that?
It wasn't myself who did it, it was the previous inspector, but in reviewing the report, when they observed engines operating, they also found CARB registration tags on the units. So when they pulled up those registration numbers on the database, they found that those units were once registered to another operator, but they were not registered to SMC Grease at any time.
But if they were registered, what's required for registration? What's the requirement? What standards they have to meet?
There are also certain engine emission tier standards that they have to meet, and I'm not the one to speak on that, but if, once they're entered into the program, those registrations will last for 3 years, and then they could be renewed, but there is also certain compliance plans that that a facility or company has to comply with if they have a fleet of engines to demonstrate that they're phasing out some of the older tiered engines, but it's, those registrations can serve for 3 years for portable sources in the field.
There was the question asked of the Coco family, is that how they acquired these engines that were not registered to them, but by previous.
Yeah, the previous inspector asked, and they informed them that they bought these units at auction.
And they were registered previously to another owner.
I don't know if they had knowledge of the registrations or the reason why those placards were on there.
Do you have no reason to believe that they were operating within belief that since these engines were once registered with Air Resources Board, that it was okay to use them? Did they use that as an excuse, a reason? Or you don't know?
I don't think they had knowledge of that registration program. I cannot speak on that because I was not the previous inspector who found them.
Thank you very much.
Thank you.
And I'm not sure if this is a question that would be for you or for the engineer, but maybe we can get a little bit of information about the CARB portable registration process so that it could be understood clearly by all the board members as we move forward. Okay, thanks. Mr. Lofgren.
Ms. Sanders, maybe you can answer this. Did the COCOs ever apply for registration of the 5 units which are the subject of the proposed findings?
Not to my knowledge.
Because I thought there was a statement made that they tried to, but they couldn't get the permit, and perhaps I can defer that question or ask it later on of the COCOs. Do we know when the COCOs purchased the first replacement unit?
I think you have a couple questions there. So the first one I want to clarify is I think the registration program is issued through the California Air Resources Board, and that's a separate document. It's separate to the AQMD permit. And so, yes, they did submit applications for 2 AQMD permits at one time for 2 different engines. Those were not affiliated with the California Air Resources Board registration application program. And then, I'm sorry, what was your other follow-up question?
On the Exhibit 2, there's a number of units which are proposed to replace the existing non-compliant units. Is that correct?
Yes.
And I think that the testimony is that they've purchased 1. They haven't purchased 6, but they've purchased 1. Is that correct?
Just identified them by number.
Okay.
This is the replacement, this is his number, so these aren't, the existing ones aren't the duals.
Right.
So just make sure you put it.
Yeah, so for the plan, I just want to clarify that those units listed in that plan, in that exhibit, are the units that would replace one of the engines that are listed in the proposed findings.
If I understood the testimony correctly, 6 have not yet been purchased. Is that right? Only 1 has been purchased?
Well, yeah, only 1 has been purchased to my knowledge.
And do we know when that was purchased?
I want to say within the last 30 days, but the COCOs can speak better on that.
Going back to something where I'm still a little confused, did the COCOs ever seek registration with, or seek a permit rather, I guess that's the better word, with the AQMD with respect to any of the non-compliant units in the proposed findings?
Yes, the 2 applications that were brought up were the ones that were, there were for the 2 John Deere engines that are in the proposed findings. Those are the ones that were determined not being able to meet the BACT requirements.
When you say they weren't able to meet the BAT requirements, are you referring to the 50, BPH requirement or some other requirement?
I'm sorry, there are certain emission requirements for the best available control technologies for engines, and when we permit them, they have to meet certain emission standards. So we found that they couldn't meet, there's certain emission tier standards that are required to obtain a permit from the district.
Thank you. And so that was the basis for denying the permit request?
Yes.
Thank you.
Any other questions? No. Mr. Sanchez, I see you. You have another witness.
Yes, the district would like to call Wilson Wong to testify. Mr. Wong, can you please state and spell your name for the record?
My name, my name is Wilson Wong, spelled W-I-L-S-O-N-W-O-N-G.
And did you take the oath?
Yes, I did.
And who was your employer?
South Coast Air Quality Management District,
And what position do you hold with the district?
Air Quality Engineer,
And how long have you been employed in that position?
a little under 2 years.
And are you currently assigned to review or handling an outstanding permit submitted by SMC Greece?
Yes.
First, addressing the issue on car versus district permits for portable engines, what is the differentiation between obtaining a permit under those two paths?
The CARB, California Air Resource Board, portable engine registration program, that's meant to be if you want to use an engine statewide. So if you wanted to use it in the San Joaquin APCD, the San Diego APCD, San Francisco, and if you want to use it in the South Coast, versus for South Coast Air Quality Management District, a permit under South Coast SCAQMD will only be good in our jurisdiction, which is LA County, Orange County, San Bernardino County, and Riverside County.
And so if ownership changes, whether it's a district permit or a CARB registration, is the operator of the unit also to get a change on those permits or registration with the district or ARB?
Yes, change of ownership or change of operator would be required.
And if the owner operator of a portable engine, either with a CARB registration or a district permit, if they let that permit or registration expire, it's no longer valid, is that correct?
That's correct.
And often the challenge in these situations is some of this equipment may be grandfathered in if that permit or registration is continued to be renewed, is that accurate?
That's correct.
However, there are times when the emissions requirements change and that requires a change in equipment.
Yes.
And so when we're saying that these units don't meet back requirements, what is the requirement for the emissions for the size of the engines listed in the proposed findings?
So under South Coast Air Quality Management District, BAC, best available control technology, the requirements for the engines we're talking about here between 50 and 100 horsepower is Tier 3 for NOx. And then for CO and PM, it could be either Tier 2 or Tier 3.
And so what is the NOx or SOx emission limits for those units?
So for NOx and non-methane hydrocarbons, Tier 3, the standard would be 3.5 grams per brake horsepower hour. And then for CO, carbon monoxide would be 3.7 grams per brake horsepower hour. And for PM, particulate matter, would be 0.3 grams per brake horsepower hour.
And did the district make a determination based upon the age and the size of these engines that they did not meet those back requirements?
Yes.
Okay. And just the last thing, if you can clarify, we've been mentioning, or the district's been mentioning, that there was confusion on the requirements for operation of these engines. Was it clear to the district that these engines were being operated to pump material when returning to the facility when initially analyzing their operations?
No, my impression at first was that it was only operating at the restaurants outside.
And so if that was the only operation that they were used for, then a various locations permit would be sufficient?
Yes.
And so once the district became aware that the engines were then again operated consistently when returning to the facility to get the material back in, at the plant? Did that change the district's analysis of any additional permitting requirements that existed?
Yes, it did.
And would electrification of that process possibly only require them to need a various locations permit?
Yes.
And just last question, so if the proposal for them to operate engines under 50 brake horsepower, that potentially could achieve compliance for district permitting purposes?
Yes.
Okay, thank you, no further questions.
Ms. Coco or Mr. Coco, do you have any questions of the witness? Okay. Senator Holden.
Mr. Wong, it appeared that you were reading from a chart based on the NOx and so on, the tier and NOx. Were you reading from a chart?
Yes.
Could we have a copy of that as an exhibit?
Yes.
Want to take a recess, or do you have extras?
I was going to suggest, but I see there's a cover on the projector. I was going to put it on the projector, but we can take a break and I can make copies.
Okay. Do you want to, do you have any other questions, or do you want to wait till?
Look at the chart,
Okay.
so I can ask the question.
Okay, if we can get the clerk to make copies. I have a couple of questions, and maybe we can just keep moving while she's making copies. Mr. Wong, the emissions of the current units, do you know what they are?
Yes.
Okay, what are they?
Maybe I'll just start with the tier levels, and then if you want me to go into the actual specific numbers, I could do it that way. But maybe just to kind of explain, tier 0's the worst, and then tier 4's, sorry, maybe I should say it this way. Tier 0's the dirtiest engine, and then tier 4's the cleanest engine. So basically, to go from worst to best, tier 0, 1, 2, 3, 4. The trailer T2 Dutes, that's a tier 1. And then the T3 Dutes, the T8 and the T9, 1 Dutes and 2 John Deere's, those are tier 2. And then the T4, we could not find engine plates, so we do not know what the emission level was, but we kind of just assume it's tier 1 for calculation purposes. And then the application that they submitted back in March 2015 is a tier 4 interim.
I'm sorry, you said the application that they submitted was for tier 4,
Tier 4 interim.
which is not one of these at all. I'm trying to follow you.
Oh, I'm referring to, at their facility, they own 6 engines in total.
Oh, okay,
So I
so
was
that's why
referring
we're
to
down
their
to
one
to
compliant
5.
engine.
Okay, the one compliant engine, okay. Just for the sake of understanding and comparison, do you have it for you, or, let me stop for just a second, because it might be on this graph that you just gave me. Let's mark this as Exhibit 4. It's titled South Coast Air Quality Management District Best Available Control Technology Backed Guidelines for Non-Major Polluting Facilities.
Ms. Byrd, if I can also provide the board the chart that Mr. Wong prepared regarding all the engines he just described. Take a
Okay.
quick break.
Okay, well, and maybe we can get this at the break too. I wanted, for comparison's sake, to know the difference in emissions with what is required of new permits versus what is already existing with these pieces of equipment. So if we could get that at a break, maybe we can take a quick recess? Okay.
Sure.
Okay, let's take a 10-minute recess and return at 10:20.
Okay. I'm not always sure what we're going to cover, Senator, but I'm prepared.
Okay, we're back on the record. When we went off the record, we were asking questions of Mr. Wong. I had an additional question, and I believe we have a document that will be distributed to us. There is some question about when the district, well, let me ask this. When did the district become aware of the use of the equipment for various and stationary purposes?
I became aware of it in a meeting back last month of September with Mr. Coco and Amanda.
2016?
This year, yes, 2016.
So when permit applications came in, and I can't remember what date that was, they came in as various location or stationary?
For the compliant engine that was submitted March 3rd, 2015, that the Form 400A was submitted as a various location.
And the ones that were rejected, what did they come in as? Do you?
I do not know.
Okay. Okay,
Do you want me to explain why they were rejected?
I did want to know that as well. What I wanted to know was the timeline for when they were submitted and the timeline that, as it addresses rejections as well, the timeline.
Okay, for the two John Deere engines, I guess we kind of labeled it as a trailer T8, T9. The two applications were received by us on January 20th, 2015. And then the engineer Francisco Escobar rejected them on January 23rd, 2015 for not meeting the South Coast SCAQMD best available control technology, the Tier 3 requirements for NOx emissions.
Okay. Were additional applications submitted or just those two for T8 and 9?
I guess when I'm looking closer, back in January 2015, there were 3 applications submitted. Okay, I see what happened. One of the applications was rejected because they said insufficient fees. I guess the permit fees of $3,482.25 was not submitted with application.
Okay, so there were 3 applications submitted in January of 2015, all 3 of which were rejected.
That's correct, yes.
2 for not meeting BACT and 1 for insufficient permit fees.
That's correct, yes.
Okay, and a letter was sent to that effect? What's the follow-up when that happens?
I was going to say, I can only speak of what I or an engineer typically does in a situation, but because I did not work on these 3 applications, I did not actually send a letter. But typically when there is not enough permit fees or it does not meet the BACT requirements, the engineer, like myself, would submit a letter explaining why it was rejected, and that would be returned with all the permit application forms and the permit fees, if there were any, back to the facility.
Is that something that's sent certified with signature, or how does that go?
I do not know.
Okay. Okay. Any other questions, board members? Mr. Lofgren?
Just so that the record is clear, with respect to the 3 permit applications submitted in January 2015. Can you identify which of the trailer units we're talking about?
I think I can only speak on just 2 of the 3 applications, but that was referring to the trailer number T8 and T9, the 2 John Deere engines.
So you don't know, with respect to the third, which of the trailer units it was?
That's correct. I would not be able to tell which trailer specifically.
Mr. Wong, from your file, can you identify which units were in operation on January 24th, 2014?
I do not directly know that.
Are you able to identify the 2 units that were on site on December 12th of 2014?
I think Ms. Sanders, can I provide information on that if you have that question?
Okay,
We can go back to her if we're done with
that'd be fine. I'll defer until that time.
Senator Holden.
Madam Chair?
Yes, Senator Holden.
Thank you. Mr. Wong, you were describing Exhibit 4 early on, but if you walk me through it very briefly, not to have you repeat everything, now that I have your chart before me, I have a clear understanding of what the situation is like, with various tiers and emissions, et cetera, et cetera. Can you walk me through that chart again?
Yes, this chart is what we call for best available control technologies, specifically IC engine, meaning internal combustion engine, in this case, the diesel engine. We're focusing on the top, maybe I should say it's page 67 is what it is on the bottom. The top line of the chart rating size will be between 50 and 100 horsepower. And basically we'll have emission limits essentially for, I guess you could say, the 4 categories: NOx, SOx, CO, and PM. For this SMC grease, for NOx, the Tier 3 standard applies when we reference that after 12/31/2007.
As you proceed, the criteria pollutants, what are you saying there? On the chart, the heading.
I'm sorry, ask that again?
See, criteria pollutants. What does that really represent is what I'm saying.
I guess we break down pollutants into criterion pollutants and toxic pollutants.
Okay.
So the criteria pollutants are what the South Coast SCAQMD cares about. We regulate, and the air monitoring stations monitor it.
Are they above or below the criteria? That's the question I'm trying to find out. What if the pollutants are determined, the emission is determined to be above the criteria, then of course there's a violation, or this the goal that they're trying to achieve?
For the best available control technologies, this is more for the standard for permitting engineering. So if the diesel engines are below these emissions limits, then we can permit it. If they're above the limits, we cannot permit it.
That's what I'd like to hear you say. Okay, carry on. Proceed then.
What I was trying to explain for the NOx, why we focus on it to say Tier 3 is that date that says after 12/31/2007. In this case, if SMC agrees was to submit applications for 5 non-compliant engines, we'll use, let's say, the deemed complete date of 2A October 13th, 2016, which would be after this 12/31/2007 date. So this is why we say the Tier 3 requirements apply, not the Tier 2.
Walk down the line, you have less than, equal to 50, but H horsepower. And
I would just ask, just the top
the top
of the
left-
chart is what's applicable to the engines in this case. I understand your question, but really we're focused on the 50 to 100 brake horsepower. That's what's being operated by this company.
Okay. Thank you. Mr. Sanchez, you will be getting to this chart as well?
We can answer questions about that chart if you would like, Senator.
We'll introduce it and discuss it.
Just a second. Can we mark it just so we can refer to it? Exhibit 5. The chart that says SMC list of engines. We'll mark that as Exhibit 5.
I can clarify and direct if you'd like. Do you recognize what's been marked as Exhibit 5, Mr. Wong?
Yes,
Did you prepare that document?
yes.
And can you describe it for us?
Basically, I was listing, in this case, all 6 of the engines, including the 5 non-compliant engines and 1 compliant one. So I was trying to show the emission tier levels, what the cancer risk would be, and also what the emissions would be for NOx and PM on a daily and yearly basis.
And so the engines listed, these correspond to the engines identified in the proposed findings,
Yes,
except for T5 where there's 2 asterisks. That's the one where the permit application is pending.
that's correct,
And
yes.
that's why we have 6 and not the 5 engines listed in the proposed finding.
That's correct.
And so is it fair to say you had to make some assumptions in determining the emissions from the operations of these units because not all the identifying information was available on all of them?
Yes,
And so let me just focus on, I'm going to say it's the 1, 2, 3, 4, 5, 6, the 7th column where you have chronic hazard. What does it meant by that?
under South Coast Air Quality Management District Rule 1401, we look at toxic airborne contaminants, and we'll break down the toxic airborne contaminants into 3 categories: cancer, carcinogens, chronic hazard, and acute hazard. My understanding is chronic hazard is something that will cause health effects to a person over a, I guess, longer time period.
And what about the next column, acute hazard?
Acute would be maybe I should just say, for the diesel engines, the toxic air contaminant that we worry about is diesel PM, diesel particulate matter. Diesel particulate matter is not an acute hazard. It's only a cancer, carcinogen, toxic air contaminant, and a chronic hazard.
And so going to the bottom of the page where you have operation, 10 minutes a day, and then below that you have 6 days a week, what does that refer to?
That was basically the operating time only at the 1600 West Policia Road, Colton, what I call the home base for SMC Greece, for how much they will operate the diesel engines at their home site only.
And so in evaluating the chronic and the acute hazard, did you assume the maximum use possible based upon those usage numbers?
That's correct, with the exception of when I wrote 52 weeks a year, I really calculate with 50 weeks per year.
Okay. And so based upon your assumptions of them using the engines for those timeframes, did you feel they posed a chronic or acute hazard risk?
It does not pose a acute or chronic hazard risk.
And this evaluation that you did, is this consistent when you evaluate similar engines, when permits are submitted in the district?
Yes.
Okay. And so the other columns to the right of the hazard risk, that's your calculations for the amount of the criteria pollutants that would be generated by the use of these engines?
Yes.
Okay, thank you. No further questions.
Right. Mr. Wong, the health risk, chronic hazard and acute hazard, where are those health risks listed somewhere where that they would be in jeopardy? There must be some place where you are able to come up with and identify what the chronic hazard would be. Where'd you get that from?
For me, I use a spreadsheet called a risk tool to calculate the cancer risk, the chronic hazard, and the acute hazard.
Oh, do you have you have that formulas available to you?
I have the spreadsheet printout for one of the engines.
Or you have a copy of the spreadsheet in front of you?
Yes, I do.
Well, it should be nice to look at it.
Okay. Also wanted to note that the spreadsheet is based upon our rules 1401, our risk assessment procedures, version 8, and the attachment M, I believe.
Thank you.
Can we go off the record so I can make copies?
We're off the record.
Ms. Bird, I could just ask him a few questions on Exhibit 5 while they're waiting for the,
Okay, we're back on the record.
Mr. Wong. You say chronic hazard pass, acute hazard pass. Why would you say it passed?
If you're asking how I determine,
They
when I-
determined that it passed. What did you mean by that, passed?
our rule 1401 has a limit for chronic hazard. The threshold is basically shall not exceed 1.0, and for acute hazard index, it's shall not exceed 1.0. So when I say it passes, I'm saying that each of the diesel engines, it's below 1.0, the limit, the threshold, and that it passes that part of the Rule 1401.
So there's no excessive emission then?
For that part of toxic air contaminants.
Right. Do you have any evidence that, or knowledge, that by virtue of the fact that they're emitting pollutants from diesel will cause a health problem? Is there a health risk at all, yes or no?
I was going to say that in our Rule 14.1 amended June 5th, 2015, we list diesel particulate matter from diesel internal combustion engines as a carcinogen on March 2008, and also the chronic risks.
Madam Chair, Mr. Sanchez, the reason why I asked the question, because just the other day I asked a question regarding contaminants being emitted from a source using diesel, and the question by the attorney was, statement by the attorney, what evidence do we have that that causes a health problem by virtue of the fact that the pollutant is being emitted as a result of burning diesel? So I'm rather confused based on the two different answers I received.
Well, I can't speak to the other case. I think what Mr. Wong is responding to is part of a analysis for permitting purposes. District Rule 1401 gives us criteria in which to make the evaluations based upon assumptions or ranges on continued operation of equipment. And just so I can pause right here, the back limit can be lowered, and as he's shown in the table, the emission limits are to be lowered after certain timeframes. So that reduction in limit could be based upon various different things, the AQMP, the SIP, whatever we've identified as pollutants we want to ratchet down, so to speak, based upon whatever reason, the EPA, the district, et cetera. And then we make assumptions based upon exposure for carcinogens, and then we try to make that consistent with those reductions in limits for the criteria pollutants and the operation of the equipment. But I believe what Mr. Wong is relaying to your questions is he's evaluated the data for his understanding of the operation of that unit, plugged it back into our health risk assessment. As far as symptomology or things like that, that's a different, someone else will be better to answer that, but his assumptions is based upon the findings for toxic air contaminants that's listed in 1401, that exposure beyond those limits based upon his calculations negatively impact people's health.
Could cause a health problem, correct.
Based upon the...
I understand so well.
Yeah.
And what I'll do is store this in my memory drum, and when I have to recall it, I know where to go find it. Thank you, Mr. Sanchez.
Mr. Sanchez? Also, could I just ask you to speak from a legal perspective, because I don't want to state it incorrectly, that there's a difference between whether or not there are excess emissions and whether or not there's a cancer risk. Those are not
Correct. I
two-
think that's what I was trying to explain to Mr. Holden. So when we have excess emissions, it could be dictated by a rule or specific by a permit to that piece of equipment. And so when we're determining compliance, we're not necessarily evaluating it for health risk. I think those issues come up oftentimes in variances in order for abatement hearings where the district wants to advocate for a certain position, and we may say that continued exposure may not pose a health risk, or if it goes past a certain period, we would be adamant that usage of that equipment cease, because it goes into the health risk concerns that I think you're asking the district today, Mr. Holden.
At some point in time, you're saying it can cause a health risk. If it's
Yes, and that's why I believe...
at some point in time, yes. It's clear to me what you're saying.
Yes.
It's clear to me what I heard yesterday, too.
Okay.
But carry on.
And so that's why we evaluate based upon our assumptions, and we usually make the worst-case scenario, based upon what we know from the operation of the facility, to adequately take a position that we think it should cease operating, or we think even though the emissions may be excess, we don't have health risk concerns to advocate that it cease operating.
Do you have any test data or empirical data that, to some degree, there's been a health problem associated with these emissions?
For this particular case, we haven't done that specific of an analysis, but I think, you know,
Anything similar to it? Where you've done any analysis at all?
I think 1401 does analysis of the criteria pollutants, and based upon the tables, that's what the evidence we're presenting, it's relied upon the assumptions in those tables.
Those are your findings, not,
Yes.
how you discover that?
The data in the tables,
Yeah, in order to have the threshold.
I'm not able to answer that at this time.
You got our answers for everything, Mr. Sanchez. Thank you.
I have the copies of
Thank you,
the things, if I can distribute those.
thank you.
You have anything else over there you're hiding that you need to give us so we don't have to ask for it? Okay. Thank you very much.
Well, you just received a document titled Tier 1, Tier 2 Screening Risk Assessment Data Input. We'll mark it as Exhibit 6. There were some questions specific to this information, I think, Mr. Holden, that you wanted to ask. If you want to take a moment, we'll take a few minutes to read. We'll take a few minutes to read the document, and then you had some questions.
Yes, ma'am.
Okay, let's go off the record for 5 minutes. Okay, we're back on the record. We have received Exhibit 6. The initial document was only one-sided, so now we have the two-sided document. In addition, we have received Exhibit 7, which at the top says Tier 1, Tier 2 screening risk assessment data input, but the difference in the two headings, I mean, the headings are the same, but the difference in the two documents is one has handwritten on it acute only, and that's Exhibit 6, and one has handwritten only, has handwritten carcinogen and chronic, and that's Exhibit 7.
Ms. Byrd, for the record, we should probably indicate that what we currently have as Exhibit 6 was substituted for what was previously marked as Exhibit 6.
Okay.
Is that correct?
That's fine. Yes, that's exactly what happened. It's been substituted with a document that is double-sided as opposed to the original 6, which was single-sided. And I believe there were some questions related to this information for Mr. Holden.
I'm looking at Mr. Wong. Exhibit 6, double size. Can you walk me through briefly this chart?
Okay. This is for the trailer T2, the Dutes. So what we're screening here is for the 1401 health risks, carcinogens. For Exhibit 6, this is for acute only. But basically, data enter in on this first page, 0.17 hours per day. That's 10 minutes a day, 6 days a week, 50 weeks a year. I also put in how close they are to a nearest residential house. Using Google satellite maps, I came out to 364 meters. And because they're next door to another commercial business, we put a default of 25 meters for a commercial. And then we consider just diesel, ICE, internal combustion engine. I guess the page to focus on when we flip through this is to flip to page 5 of 11.
Before you could continue, you said distance for residential, that's 360 feet?
This is in meters, 364 meters.
64 meters. Okay, meters, correct, absolutely. And for commercial, 25 meters. Okay, carry on.
I was going to say the page to flip to is page 5 of 11. And it will be labeled on the top left corner, hazard index. And there will be a column that will say acute pass/fail. And the whole column for every single part of our body, from bones and teeth to skin, will list pass, which is what I would expect because diesel PM is not an acute toxic air contaminant.
Okay, in your opinion, what if the source of the admittance was less than 364 meters, like 50 meters residential? Would that increase the health risk?
For acute, it would not affect it because diesel PM is not acute risk, but for the carcinogen, the cancer, and the chronic, in getting closer, 50 meters as opposed to 364 meters would increase the risk.
For carcinogens?
For carcinogens.
Okay. Anything else we should need to know without understanding what you've done here on total?
I'm sorry, repeat that again?
Anything else we need to know that you've done here that we don't understand in total?
To kind of answer your question going back, I think 5 or 10 minutes ago, I think you were asking about how do we determine diesel PMs are carcinogen or what gets it on this table. I believe the The State of California OEHA, Office of Environmental Health Hazard Assessment Agency, they do studies on, I guess, the health risk to kids and adults, and they will update and change the standards over time. South Coast AQMD, our Rule 1401, we have to update and reflect what the State of California OEHA finds and reports. So that's the reason why we, in March 7, 2008, we considered diesel a carcinogen, as opposed to in 1965, we didn't worry about it.
Very good. Thank you. That's your source of data that's important to know.
Any other questions?
No, I just wanted to follow up on Mr. Lofgren's questions. If I
Okay,
may.
and then I'd like to allow,
Excuse
after
me,
that.
before we
Oh,
do that, I do have one question for the gentleman, and it only relates to, it says, application deemed complete date, October 11, 2016. What does this refer to?
Typically, when someone submits an application, we'll have a date we received it on, and then within 30 days, the engineer, like myself, is supposed to either deem it complete or reject it and send it back. Deemed complete would be that the applications are all filled out completely, every form's there, and the permit fee is included, and that we believe we have enough information to actually process the permit.
So was an application for T2 submitted, well, approximately when was it submitted?
There was no application for T2. I only put that date in 10/11/16 so that this risk tool spreadsheet knows which chart of table of numbers to grab from, because based on the date you put in there, it changes the results.
Thank you.
Mr. Sanchez?
Thank you. The district would like to call back Amanda Sanders. Ms. Sanders, were you able to review the inspection notes for the inspections for the issuance of the NOVs in June and December 2014?
Yes.
And were you able to determine what engines were observed on site during those inspections?
Yes, during the June 24th, 2014 inspection, the two John Deere engines were observed. Serial numbers PE 4045, D415, 862, and PE 4045, D415, 864.
And what are those identified in the T numbers by the facility and in our, I'm sorry, identified by the facility?
They're either T8 or T9. I'd have to look further. Oh, I'm sorry, I have a note right here. So the unit with serial number ending in 864 is T8, and the unit ending with 862 is T9.
And both those units were observed both times during the June and December 2014 inspections?
Yes.
Thank you.
One just follow-up question. Which of the two units was in operation in December of 2014?
They represented both were being used, but the district inspector did observe one of the units operating, and that is the unit ending with this serial number 862.
Thank you.
Do you have any questions of the witness?
Yes, just one, just so, for understanding purposes, Mr. Wong. Your analysis here is kind of a different language for me, so I'm sorry. Are you stating, just so I understand it, that our motors, based on the usage that we use them, they are a risk or they're not a risk? Because I'm reading past, so I just need to understand, are they causing a health risk?
The 5 engines in question at 1600 Wells Policia Road, Colton only, would not pose a risk. It would pass our 1401 rule.
And may I ask why Colton only? I mean, if it was used 20 miles away, would it cause a risk there? How do you determine the difference of where it causes a risk?
I think the reason why is for at least for 1600 police here, because it's an exact address and the engines return there on a recurring basis. I actually know the distance to your nearest commercial neighbor and your nearest home, as opposed to Panda Express nearby here. I don't know the nearest residential and commercial.
Okay, I understand. So they do not pose a health risk.
For the toxic air contaminants, they do not pose a risk.
Thank you.
I'm sorry, we got kind of out of order there, Mr. Sanchez. I was under the impression she was asking a question of the other witness. Are you done with your witnesses?
Yes, no further witnesses from the district.
Okay. Now is your turn. No, it's okay. No, now you have a chance to explain to us. And I would ask Mr. Sanchez if he might kind of help you to make sure you know what you should address, to basically present your case.
In terms of our motors, we have no problem replacing them whatsoever. If they don't meet the correct standards, we have no problem replacing them. We have replaced one, even though we weren't asked to yet. We took it upon ourselves to replace it. We've ordered our second motor as well, which will be received and installed by the end of this month. In addition to that, we have already purchased and installed the electric motor for on-site to assist with those emissions as well. The only thing we are asking for is a timeline to comply and replace every single motor. We're not asking to keep these motors. We will replace them if they don't meet standards. The concern we have is we just got out of two serious issues in business. One, we're still coming around from the recession. Two, California passed the emissions law, which cost our company to invest over $1 million in new trucks. We're still on the rebound of that, increasing our expenses immensely on a monthly basis. We didn't have that type of capital to go out and pay for it up front. Again, this is going to cost us over $100,000 to replace in these motors. We just ask that, can we have a timeline, like every 2 months that we've replaced another one and replaced another until we comply fully. Currently, we have 6 motors to replace plus a unit to help the emissions in our yard, which technically means 7 motors. We have replaced 3, and we are just asking for a fair timeline to replace the rest. And I have one question. I'm a little bit confused. I understand that anything over 50 horsepower we must have permitted, correct? When we were at our office, and we were the 4 of us talking, and one thing that I was confused about is you had mentioned that I needed to permit motors even if they were under 450 horsepower. And this is when I was with the 4 of us having a conversation with Sal, stating that then it's a moot point. Why are you going to take the chance of getting a smaller motor if you still have to permit it? So I just want clarity. If it's under 50 horsepower, no application and no permit is required. Because 2 weeks ago, I was under the impression that it was when we were talking in our conference room.
Mr. Sanchez, would you like to address that?
Yes, I can call Mr. Wong as a witness to quickly address that. Mr. Wong, can you clarify, is that for certain that as long as the engine is under 50 brake horsepower, no permitting is required by the district?
I was going to say, as of today, we look at Rule 219 for exemptions. Rule 219 exempts diesel engines under 50 horsepower, but I should put a caveat to say that if the governing board ever changes Rule 219, it could change in the future, and you may need a permit, I don't know, 5, 10, 20, 50, 100 years down the road.
But today we do not.
Today, you do not.
Okay, no further questions.
Mr. Wong is on.
I'm sorry.
Yeah, Mr. Wong, you mentioned grandfather clause, right? In the event that the governing board changes, make it more restrictive for using these engines for less than 50, would they be grandfathered in, the ones that are in compliance at the time that the new requirement put in place?
If Rule 219 change, they, there's no such thing as grandfathering to say that you would not need a permit. To give an example, in downtown LA, they'll have emergency generators that are, let's say, 200 horsepower. Back in 1965, they were exempt, but I believe in 1989, we changed Rule 219 for engines to be basically down to 50 horsepower. So that 1965 engine that was okay back in 1965, in 1989, we require a permit for that engine.
And they were given time to comply.
I don't know, but I assume there's usually, yeah, some kind of time frame and also.
You wouldn't expect it to be instantaneous or overnight. It's cost prohibitive.
Yeah, I know 219 has a part in it that says as long as you do apply for a permit within 1 year of 219 changing, there would be no penalty.
Okay, thank you, sir.
Thank you. Questions for Ms. Coco?
Yes,
Go ahead, Mr.
thank
Sanchez.
you. Were you under oath when you made your opening statement and when you testified right now, Ms. Coco?
Yes, I was.
And I think you heard in my opening, the district has a concern of how quick you're going to electrify processing of the material at the facility. What is the facility's plan to electrify operations for receipt of material at the plant?
Just so I can understand, electrify meaning the electric motors?
Yes, so my
We already
understanding
have
is,
that.
I'm sorry, go ahead.
We do already have the electric motor on site.
And when is it supposed to be installed and operational?
October 31st, 2016.
And what arrangements or have you made, or are there any requirements with permitting in the city that you operate to install that equipment?
Yeah, it's a very small motor, so is it under 50? It's under 5 horsepower, so no permitting should be needed for this.
And why do you have to wait till the end of the month to install that equipment?
Yeah, it's installation. It's putting it in place, installing it.
And do you have sufficient electrical capacity to run, to operate that engine?
Absolutely, we were upgraded a few years ago. And it's yeah, you need to speak. Well,
We need to go one at a time.
sorry,
If-
it is
if-
an
if
electric
this-
motor, so.
If it's something you can't answer, you can say, I can't answer it, and then we'll go to the next witness.
Okay.
and we can do that.
Okay, thank you.
Regarding what's been marked as Exhibit 2, was that a document prepared by your company and provided to the district?
Yes, it was.
And so of the 6 engines provided there, if I understand correctly, you've already replaced T5, and that unit is already in operation, is that correct?
That is correct.
And so beginning with T4 at the top of the page, your plan is to replace that on December 30th, 2016?
That is correct. We've already ordered and paid for the motor, and we're just waiting for it to come in.
And so based upon T5 already being replaced, could you move up the timeline for the remaining 4 engines?
We just purchased this one, so based on what we're asking here is if we could get until February to go to the next one. Because
Okay.
we just did this one.
Okay, because
It's-
I'm just looking at it in terms of I understand you went out of order, so to speak, but.
Yeah, we are definitely out of order. My apologies. I can't answer that question, but I'm sure Sal can.
Okay. What impact, if any, would having to stop operating until you replace all these engines and electrify the plant, what impact would that have on your business?
We would be out of business
And what do you base that opinion on?
because we are a pumping company. Everything we recycle, we pump. We have to go extract it, and it requires an engine to operate the pump. So we would be out of business and almost 50 employees as well.
And how confident are you that the electrical engine will serve the needs of your operation in getting the material from the truck into the plant?
I'm not qualified to answer that. That would be more sales department.
And when you replace these engines as proposed in Exhibit 2, will the engines be operated by themselves, or will they be operated in tandem with the trucks? Meaning, does the truck have to idle to power the engine, or these engines are powered by themselves?
They will be powered on their own. They do not need the truck.
Okay. Thank you. No further questions.
I have one question. How long have you owned this business?
Next month will be 22 years.
22 years. Have you ever had permits from the district before?
AQMD district?
Yes, AQMD.
No, ma'am.
Okay. And when you obtained these engines, when did you obtain the engines?
Various times, we never bought them brand new. All of our equipment has been bought used. So when you buy a trailer, generally a pump motor is installed on it, so we bought it with the trailer. That's why never knowing to register it. We just registered the trailer when we purchased it.
Okay. I had one other question. Oh, yes. Exhibit 3 that was distributed by the district, it just happens to talk about contractors. And is it feasible to have someone to pick up the grease and return it to your site
Absolutely not.
during the period of time that you would be installing the engines?
It would
And-
not be cost effective for us. We would not be able to, with the cost that a company would charge us, we couldn't even turn around and make a profit on it to our customer. Two reasons being, number one, we do a lot of government jobs, which we have contracts that we cannot subcontract anybody. So that would be one issue that we have, and that's a large volume of our business. Number two, if I went to my competitor and asked them to go pump and bring it to me, their fees, they're my competition. They're not going to do us a favor. They're not going to say, no problem, let us do it below market for you. Therefore, it would be a loss for us financially. Not to mention, I wouldn't even know that somebody would want to do that. And I would like to know if they're permitted, because I probably have to guess that they're not. 22 years in being in business and working for another company, so I worked for another company prior to us starting our own company. We've never heard of this. And even when I've been speaking with everybody, they don't even have another company like us on the radar here that's got these permits. So I guarantee you, you guys are going to be very busy going after all of our competition because we didn't know about this. None of us did.
Is it possible that prior to having all the engines, that you could, let me see, let me backtrack. I'm thinking that, I know that you're replacing the engines, but do you need all of these engines in order to operate? Do you need to go all the way to August 17th to be able to still efficiently do your business?
Yes, ma'am. We do have 6 trucks going out on a daily basis. None of them sit back. Because of the amount of clients that we have to have 6 trucks on the road.
Okay. Any questions, board members? Mr. Lockwood?
Just to clarify, I think you answered this, but I think I missed it. With respect to T4 on Exhibit 2, it says replacement date October 30th. Is that still the anticipated replacement date?
Yes, sir.
And then the next one that has to be replaced is T2, and that's February 2017, right?
That's correct.
And maybe this was answered, but I didn't understand it. Is it possible to move up the dates by 2 months, since you've got October for the first one, and then you don't have to do one in December because that's already been done? Can the other dates be moved up by 2 months?
I'd like Sal to be able to answer that more clearly, because I think here where it says T5, my understanding is we've already replaced that one, so I think our spreadsheet here might be off, so I think Sal might be better to answer that question.
Sure, thank you.
Any other questions?
Ms. Coco, I think you said you do government work as well. That's a major part of your business.
Yes, sir.
Is that federal, state, county? State
State and
government.
county.
State and county. If what's being required of you is to permit both sites where you retrieve the grease and where you process it, then you have to get concurrence from that government agency, I would think.
Yes, sir.
Have they told you that before?
Yes, we are in compliance. They ask for our permits on site, because we do bring it back to our product, and in transit. So we have to have, through the state of California, the Department of Food and Agriculture, we have to have a permit to be able to just transport it from one location to another and to unload it onto our location. And so when we do go out to these government contracts and we bid, they ask for all of our proof to qualify to bid, and we have all that.
You satisfy their requirements?
Absolutely.
What permit did you provide them to support that you satisfy their requirements?
We provide the Department of Food and Agriculture permit for transportation and rendering. They ask for our registrations, insurance. They have to have all of our employees pass a screening to make sure that they're able to, because these are federal prisons, so they have to go on site. So we have to go through a very large amount of paperwork. And then we have to show them our county permit to operate in their county and in their city, and our business license where we bring our product back as well.
Well, there's some section code which provide a variance for that kind of operation when you're doing something for jails and the government, but you never requested a variance.
I'm sorry, I don't understand the variance for.
It's to allow you to be permitted to operate your business, even though you're not meeting the necessary requirements from standpoint of emission.
Not meeting the necessary requirements, meeting our motor, and this,
Yeah, for the
we were
emission.
never aware of that, and they've never asked for that either. Had we have been aware of this, we wouldn't be here today. We would have complied prior to this even happening.
Well, something to be determined. Thank you.
You're welcome.
Any other questions?
Not of her, I don't.
Okay, your next witness. Let's just state your name and tell us that you took the oath. Mr. Coco.
Yes.
Okay, just spell your name, state your name, spell it, and just mention you took the oath, and then you can either give us information or we can ask questions.
Okay. My name is Sal Coco, SALCOCO. I'm the president of the company. And yes, I did take the oath.
Okay, if you don't have any statement, then I'll ask Mr. Sanchez to ask questions.
Thank you, Ms. Byrd. Mr. Coco, the district has some concerns on whether the electric engine that you're going to be used to receive product at the plant is sufficient without having to use the engine on the truck. Can you elaborate on your confidence that electrifying the engine on site will meet all your needs for accepting product?
Yes. What the electric engine will do is we will gravity flow into a holding tank. And as the gravity flow into the tank, an electric pump will pump into the holding tanks.
And do you have any familiarity from other competitors, or how did you decide that this specific pump would meet your needs at your facility?
We've used these pumps in other areas in our plant. And I decided to do this to help us get by this as we replace these motors.
And what's the price of that pump?
The pump and motor is about 5,000.
And what would happen if that pump went down? How would you be able to get product into the plant?
We also have diaphragm pumps that run off a compressor. That could be a backup.
And have you had to use those backup, those diaphragm pumps in other scenarios before?
Yes, we also use diaphragm pumps for different kind of product. The only difference would be from the electric and the diaphragm pump would be time. It takes much longer to use the diaphragm pump, but it still can be done.
And how confident are you that you'll be able to fully switch to the use of the electric motor and no longer using the engines on site?
About the 90%.
And what concerns you have that you may not meet that October 30th deadline?
I have no concerns that it will be done.
No further questions, thank you.
Questions, board members?
This is a family-owned business?
Yes, sir.
Thank you.
Welcome.
Mr. Lofgren, did you have a question? I thought, I'll go ahead if you're still looking. Okay. There was a question as to timing, and I'm not sure if just to follow what you have here, the plan that's been submitted, I believe that Ms. Coco testified that T5 has already been replaced. And according to your timeline here, it was to be replaced 2nd in December. Is that correct?
Yes, the reason, T5, what we did, this engine's already been replaced with the 60 or 59 horsepower. These are one of the engines I replaced on my own.
Okay.
And the reason I'm replacing this again is now I'm going to a 46.6 horsepower. And the reason I'm doing that, at that time, when I replaced it the first time, I did not know there was going to be a $7,000 permit that we were going to need to run this engine. So 7,000 times 6, that would have been another $50,000 I'm going to need for no reason. So I decided to replace that engine also.
Okay, so everything is, so the engine that's been replaced has not been replaced already with the Tier 4 engine. I'm sorry, I'm trying to follow what you're saying here.
The T5 has been replaced with a Tier 4 already.
Okay,
But the
okay, it has.
horsepower is over 50.
Okay, but it's over 50, so you're replacing that
Again.
again. Okay, that's what I didn't follow the first time, I'm sorry. And when will that be replaced?
As notes on December 2016.
It will be in December. Okay,
Yes.
so actually what we have here on the timeline is accurate for your plan for replacement. I was under a misunderstanding. So we're starting with Tier 4 and replacing it on October 30th?
Yes,
And then Tier 5 and so forth as it is stated here on your plan?
yes.
Okay. That was just a little bit confusing for me. I don't know why. The other question I had was, are there other companies in the area who do what you do?
Yes, there is.
Okay, and you don't know of them using any of this equipment that you're proposing?
Yes, I do.
They do?
Yes, I do.
Oh, okay. So there is a record of it being effective and because other companies use it?
Yes.
Okay. I wasn't clear on that either. Okay. I think that's all my questions. Mr. Lofgren?
My question was answered, so I'm fine.
Okay.
I have one
Senator?
additional question after the senator.
Okay, Senator Holden?
Do you know where your competition being regulated as you are?
No, I do not know.
But you don't know that being cited for any, well, you don't know, all right. It's Sanchez.
Thank you, Senator. Mr. Coco, on the replacement for T5, which does require a permit, would you be willing to accept a condition on that permit that it not be allowed to be run on site at the facility?
On T5,
Yes.
I would have to run it on the facility.
And why is that?
This certain trailer delivers product to other cities which run digesters, and that's what this trailer would do. And this trailer would have to use a vacuum to pump out our holding tanks.
Well, I think that's the concern of the district, is that you don't operate any of these engines on site. And so T5, which has a permit pending, it's the district position that you couldn't run it on site. So are you saying the electric engine wouldn't satisfy your needs for the T5 engine?
The electric engine is designed just to unload trucks, not to load trucks.
So that's what I'm saying. Would that be able to unload the materials in trailer T5?
T5 delivers product. It doesn't bring in product. When T5 arrives to the yard, it's empty.
Okay. Yeah, it is. So that would need it. Oh. Okay, thank you.
Any other questions?
May I ask Mr. Wong a question?
Okay, let's go back to Mr. Wong.
Mr. Wong, I heard you state earlier words to the effect that the governing board changed the requirements for engines in excess of 200 horsepower. Did I understand you correctly? They were not grandfathered in when they changed the rules.
My understanding is that there was a time, I believe before 1999, that all engines below 500 horsepower were exempt. And then Rule 219 was changed. They lowered that 500 horsepower threshold down to 50 horsepower.
So, and the 50 horsepower was exempt at one point in time.
Yes.
When was it determined it was no longer exempt? It's not exempt now. They got 50 horsepower, and they're saying they just cannot automatically operate the system because they're no longer exempt. They got to be less than 50.
I'm trying to understand if you're asking exactly 50 horsepower?
Right. Is it currently exempt? Yes or no?
I believe the 219 requirement is, it will say greater than 50 horsepower.
Or the ones that they're operating greater than 50 horsepower?
Yes, well, we know for sure 5 of their 6 total engines on site are greater than 50 horsepower, and one's unknown.
One is unknown, okay. It's on here someplace. How much greater? I saw your chart before. How much greater each? Just go down the list, than 50 horsepower.
Maybe I should just say, T2 is 68 horsepower.
Okay, good.
I should have said that T3 and T4 I actually do not know. And yeah, but we assume it'd be 70 horsepower just based on the same amount of the work they're doing to pump the grease and wastewater from 16 feet underground into the trailer. And then the T8, T9 is 80 horsepower.
Okay. The respondent proposed, based on Exhibit 5, the corrections they were making in order to be in compliance. I believe that's right. They wrote, you did the Exhibit 5.
Exhibit 5 is the district's evaluation and assumptions of the data and emissions from the engines observed on site.
All right.
So respondent is proposing to achieve compliance by no longer operating these, 5 of those engines, by replacing them with engines that meet the emission standards and are below district permitting requirements.
Okay. So, in your opinion, the respondents to make a good faith effort to comply with the,
I can address that in my closing.
pardon?
I can address that in my closing.
Okay, very good.
There are no other questions. Mr. Sanchez, is it possible for you to talk with the respondent and see if this schedule in any way is something that the two of you can work with, or?
Yes, I would just ask if, I will pursue that during our upcoming break. If the board has any direction for efficiency to include in those discussions, I'd be glad to hear it prior to my discussions with respondents.
Okay, and Mr. Wong, you've seen Exhibit 2 and the equipment that's being listed and the horsepower and the tier listings. Based on that information, would you say if all of this was accurate, that it would be likely that they would be permitted?
Looking at Exhibit 2, I see they all say engine type Tier 4, horsepower 46.
Or are these not required to have permits because they're under 50?
That's what I was going to get at, that because they're under 50 horsepower, they would not require permits at this time.
Okay.
They would be exempt.
Okay. Okay, so let's just take maybe about 10 minutes.
Before we do that,
sorry.
he asked, maybe I think it's important for me to know, and maybe you also, that they implemented a compliance schedule that would not put them out of business. Given that it seems to me that they're also making a good faith effort to comply. Okay?
Okay, so let's take maybe 10 minutes, Mr. Sanchez, for discussion with the respondent to see if you can reach an agreement as to whether or not the schedule will be possible and acceptable to the district.
All right, thank you.
We're off the record until 11:45.
Yes.
Okay, we're back on the record. Mr. Sanchez, did you have any potential change that you might like to make to how we started this process and whether or not this plan would be acceptable?
Yes, thank you, Chairman Byrd. Based upon the testimony provided by respondents and our evaluations being consistent with what they represented on the use of the existing non-compliant engines, we are agreeable to their time frame proposed in Exhibit 2, and we would change the proposed findings to reflect an order that embodies that timeline for them to replace the engines, and we are okay with that schedule based upon the emissions in the interim.
Thank you. Closing, since we're at that point.
Yes. As respondents represented, there was some confusion on the use of their engines on site. We had been gaining familiarity of this industry based upon proposed rule 415.1. And so this is not an industry that the district has not had a lot of oversight, but for when there's been odor emissions from rendering or rendering grease facilities. When we initially cited the facility, our assumption was they would just replace the engines with compliant engines. The process then became a bit stalled when we learned that they were using the engines off-site, which would be satisfied by a multiple locations permit. However, the use of it on-site on a continuous basis, we felt would require a stationary permit for the use of these engines. Obviously, that is quite onerous on a facility to have to pay for and hold permits two permits for one piece of engine. And so when we had met with respondents at the district, we were happy to hear that they were seeking to electrify those operations at the facility, which would remedy that issue, and they would replace the engines with engines below the brake horsepower needed for permitting by the district. So based upon the timeline, the district is understanding and reasonable that there are costs associated with them doing this. This timeline is expeditious, and as I just represented, the emissions are below health risk that the district puts paramount in evaluating these type of situations and reaching a solution. So based upon that, the district's initial proposal that they cease and desist operating all these engines until they achieve compliance, we're willing to modify that position, and as laid out in Exhibit 2, if the facility electrifies their pump at the material, requiring no further operation of T4, T2, T3, T8, and T9 for loading of material at the facility, that be done through an electrified process, and only the engines be ran when receiving material at their various locations. The district is willing to seek an order that reflects that rather than the originally proposed order to the board. Thank you.
Thank you. Ms. Coco or Mr. Coco, would you like to make a closing statement?
I would just like to thank you for working with us. We really appreciate it.
Thank you. Are there any members of the public who wish to testify? Seeing none, we can start our deliberation.
Before you start deliberation, again, just kind of a formality, you might want to admit the various exhibits which have been marked into evidence,
Okay.
if there's no
Those that were
objection.
requested, I will.
Or,
Yeah,
unless-
I'm sorry. I think the district presented exhibits 1 through 7. I asked that those exhibits be admitted in evidence.
Any objection, Ms. Coco, Mr. Coco?
No, ma'am.
Okay, exhibits 1 through 7 will be entered into evidence. Thank you. Oh, yes, we didn't mark the findings and decisions, did we? And since we're at 7, let's mark the findings and decisions as Exhibit 8. I'll start our deliberation if no one else wants to do that and jump in. This facility, I think what's notable is that there isn't a lot of understanding, or as Mr. Sanchez stated, I guess, that their Rule 415, the district has not had a lot of oversight because they don't deal with these types of facilities, because there aren't a lot of these types of facilities. So that in itself, I think, is a reason to try to work with this facility. Also, I wanted to point out for the other board members, Rule 806, which addresses findings in an order for abatement, says that we have to find that the respondent is in violation of Section 41700 or 41701 of the Health and Safety Code or any rule or regulation of the South Coast Air Quality Management District. And secondly, that the order for abatement will not constitute a taking of property without due process of law. And third, that if the order of abatement results in the closing or elimination of an otherwise lawful business, such closing would be without a corresponding benefit in reducing air contaminants. I think the testimony that we have heard from the district, at least, that the health risk is not a concern for this operation. I think that in light of the facility's ability to move forward and the district's acceptance of the schedule that they are proposing, that we can find good cause to issue this order. I think that initially it sounded as if the facility, just on paper at least, that facility was not in cooperation, and that the facility had since 2014, 15-ish, just kind of ignored the requirement to move forward. But there was a misunderstanding, obviously, with the facility of what that looked like. I think the idea that the facility has already invested a substantial amount of money makes a difference in my finding of good cause to issue this order, and the fact that the facility is stating that they will continue to invest, and there was a substantial amount, and I can't find it right now, but I will. And there are also 50 employees at this facility, and that's to be considered in the balancing of whether or not the closing or elimination would be without a corresponding benefits to air contaminants. With the air contaminants, based on the testimony of the district, with the health risk not being a concern, and the ability for this facility to move forward from this date, I think that we can make a finding for good cause to issue this order. And the district is also in agreement. Any other comments?
I concur with your comments. I think there's good cause, and I commend the facility for its cooperation.
So I think we're modifying the order of abatement. Is that not correct, Mr. Sanchez? As you stated.
Yes, I think it takes a little bit more wordsmithing to that. I was trying to think of a way of how could we wrap this up all right now.
Well, whoever makes the motion can address that.
For one point of clarification, based on Mr. Sanchez's statement, where the effort being made to use the electric motor at the home base, but where they're retrieving the grease or whatever the case may be at remote sites, you saying the remote sites are to be permitted, or the trucks to be permitted to transport from the remote sites?
The order that the district would be seeking is that the facility electrify by October 30th, 2016, and that they cease operating the equipment identified in Exhibit 2 based upon the proposed timeline. So the order would allow them to continue using the 5 engines listed in the proposed findings up to a certain deadline in which they are to cease and desist operating them as proposed by respondent.
But that's not specified, the time, up to a certain timeline.
Yeah, the timeline would be specified in Exhibit 2,
Okay.
which is essentially beginning on October 30th, again on December 2016, February, April, June, and August. And actually, looking at that now, I would just propose that we put
Exhibit 2.
the specific dates for each of those months.
That's for the trucks.
It's only the engines.
The engines.
The engines. The trucks don't require
I mean,
permitting.
just for the engines.
Yes.
What about the military bases or the jails? There's no permit to retrieve the grease at that point. Is that correct?
All the district's permitting concerns is that the non-compliant status of these engines, and so the order is just intended to cease the operations of those engines.
Any other comments? I'm looking through the calendar to get to 2017 so we can place some dates, specific dates. Mr. Sanchez, I would recommend that we just put the last date of the month for these, if that is acceptable to you.
That's agreeable to the district.
Okay. Is that agreeable, Ms. Coco and Mr. Coco? Okay, so the first date is 10/30/2016. The next date would be December 31st, 2016. The next date would be February, it's not a leap year, is it? February 28th, 2017, April 30th, 2017, June 30th, 2017, and August 31st, 2017. And we'll work on the wording after we, I will ask you if you will have some wording. So I'll go ahead and make the motion if there are no other comments. Okay. In the matter of South Coast Air Quality Management District versus SMC Grease Specialist, Inc., case number 6061-1, I move that we issue this order for abatement for good cause with the order that's included and will be included with changes in Exhibit number 8. I'd like to make changes on the first page of Exhibit 8. On line 24, to delete the name Edward Camarena. It also proceeds to 25, Chair. And on 25, to delete Julie Prusak, Vice Chair. To leave Patricia Byrd, to insert Douglas Lofgren, and to leave Honorable Nate Holden. Then in the order itself.
Excuse me, also, I think you'd want to delete Dr. Lee.
Oh, yes, delete Dr. Lee. Okay. In the order itself, on page 4, I think that's where we would insert wording, and I would like to give Mr. Sanchez a moment to possibly come back with some wording, but basically it would address electrifying the facility and the date by which the equipment would no longer be used. That's mentioned on page 4. So I'll take a few minutes off the record.
Yeah,
We're back on the record. Thank you. We have received the revised version of the findings and the order. And I think maybe we should take a minute at least to look at it before we end our motion. So let's just take maybe 5 minutes to at least overview. We're off the record. If you will point out where the changes were made.
Yes, beginning on page 1, lines 23 through 25, I removed Chairman Camarena, Ms. Prusak, and Dr. Lee, and inserted Mr. Lofgren's name there.
Okay.
And then going to page 4, I see that I didn't remove one of the paragraph's numbers, but I provided a copy to the clerk. She can kindly remove that for me. And so then going on page 5, I inserted paragraphs 1 through 6. Oh, I'm sorry, starting on page 4 of the order, I reworded the heading in the order to now it reads, therefore, subject to the aforesaid statements and good cause appearing, the hearing board hereby orders respondent to immediately cease and desist from operating the following 5 portable diesel-powered ICEs in a manner that violates District Rule 203, or in the alternative comply with the following conditions and increments of progress. I added the heading conditions and increments of progress. Going on to page 5, beginning with paragraph 1, I added respondent by no later than October 30th, 2016, shall electrify the pumping of material at the facility and cease and desist from using the following 5 portable diesel-powered ICEs listed below to pump material at the facility. Paragraph 2, respondent by no later than October 30th, 2016, shall cease and desist from operating T4, unidentifiable. Respondent by no later than February 28th, 2017, shall cease and desist from operating T2, Deutz model F49912, serial number 818-7360, rated at 68 brake horsepower. Respondent by no later than April 30th, 2017, shall cease and desist from operating T3, Deutz model BF4L2011, serial number 10332971, unidentifiable BHP. Respondent by no later than June 30th, 2017, shall cease and desist from operating T8, John Deere model 4045DF270B, with serial number PE4045D415864, rated at 80.46 brake horsepower. Respondent by no later than August 31st, 2017, shall cease and desist from operating T9, John Deere model number 4045D F270B, with serial number P5404-5D415862, rated at 80.46 brake horsepower. The next line, the hearing board shall retain jurisdiction over this matter until I will defer to the hearing board to determine a jurisdictional deadline, and those are the changes that I've made to the initial proposed findings.
Okay, thank you. So you've inserted everything from Exhibit 2 directly into the order.
Yes, and I also, for clarification, I listed the T model numbers as identified by the facility with the corresponding descriptions ascertained by the district.
Okay. And I think before we took our break, I think I had just made the motion, and as I will just amend my motion to include those items that were just read into the record, and also add on page 5, I'll give it 90 days to go out November 30th, and number 7, jurisdiction for the hearing board. And that would be all the changes that I would make. I see you already took proposed out of the caption, so those will be the changes. Is there a second?
Second.
Mr. Holden, a second? Okay. Mr. Lofgren, how do you vote?
I vote yes.
The vote is 3-0. It passes. So you will be granted this order. And if you have any questions, make sure to clarify with the district so that we don't have a period of time that things go and there's not an understanding. Okay. Any other business, board members? If not, we are adjourned. Thank you.